Rhode Island may be the smallest state in the country, but its tenant protections are anything but small. If you're a landlord here, you're dealing with a robust legal framework that takes habitability very seriously. Rhode Island's habitability requirements are governed by the Residential Landlord and Tenant Act, found in Rhode Island General Laws, Chapter 34-18. On top of that, the state has a detailed minimum housing standards code under Chapter 45-24.3 that sets specific requirements for the physical condition of rental properties. Under Rhode Island law, landlords must comply with all applicable building and housing codes affecting health and safety. You're required to maintain the structural components of the property in sound condition, provide adequate weatherproofing, including functional windows and doors, maintain plumbing in good working order with hot and cold running water, keep electrical systems safe, ensure the heating system can maintain a minimum of 68 degrees Fahrenheit from October 1st through May 1st, provide working smoke and carbon monoxide detectors, keep the property free from insect and rodent infestations, and maintain common areas in a clean and safe condition. What stands out about Rhode Island is the state's minimum housing standards. These get very granular, covering things like minimum ceiling heights, adequate natural light in habitable rooms, proper ventilation in kitchens and bathrooms, and even the condition of interior wall surfaces and flooring. If you've never reviewed these standards, they're worth reading because they go well beyond what most landlords expect. Rhode Island also has a strong code enforcement system. Local building officials can inspect rental properties upon complaint and issue violation notices. Landlords who fail to correct violations can face fines and, in serious cases, condemnation of the property. When it comes to tenant remedies, Rhode Island gives renters several options. Tenants can provide written notice of a habitability defect, and if the landlord doesn't address it within a reasonable time, typically 20 days for non-emergency issues, the tenant can pursue rent escrow through the district court. This means they pay rent to the court instead of the landlord until the repair is made. Rhode Island tenants can also use the repair and deduct remedy for certain issues, and in cases where conditions are severe enough to constitute constructive eviction, they can terminate the lease. The state also allows tenants to seek damages in court for breach of the warranty of habitability. Retaliation protections in Rhode Island are strong as well. Landlords are prohibited from taking any adverse action within 6 months of a tenant exercising their rights, including filing complaints, requesting inspections, or joining a tenant organization. For a complete guide to Rhode Island's habitability requirements, visit tenantscreeningbackgroundcheck.com. Subscribe to stay current on every state's landlord-tenant laws.